key purpose is to act on behalf of the shareholders. And they're acting on behalf of the shareholders in ensuring that value is created for all stakeholders, including the shareholders that appointed them, and also to ensure sustained success of their organization. That is the going concern of their organization. So this is the key purpose. It's very important that anybody charged with governance is mindful of the fact that he is doing, or he or she is doing it as a fiduciary. And a fiduciary is someone that acts in the interest of others. According to Forbes, a fiduciary is a person or organization that acts on behalf of another person or persons with a legal and ethical obligation to put that person's interest ahead of their own. So it's very important that as a member of the board or anyone charged with governance to always have it at the back of your mind, whatever you're doing is on behalf of the shareholders. And that means you have a legal and an ethical obligation to act in the best interest of your shareholders and also other stakeholders. So we have with us Mr. Colin Egemonye. He is the managing partner and head of corporate commercial law at Goldsmith Solicitors. Mrs. Anita, she is a partner in Orchid Chambers and the pioneer director in Chrysalis Bail and Bond Limited.
So what are the rights of shareholders in the boardroom? And this is a very important question because, you know, most times we'll come across disputes where somebody says, oh, I'm a shareholder and, you know, XYZ has been done. And, do we exercise any right over the boardroom, strictly so-called? They can exercise rights insofar as it relates to appointing the directors of the company, removing directors of the company, determining the remuneration and benefits of the directors at the general meeting. They can rectify actions taken by the board of directors and make recommendations to the board of directors. You will see just back on this slide, you see that shareholders do not have the right to day-to-day management of the company, right? They have kind of oversight functions, as it were, in terms of directors, but they don't have day-to-day responsibility of running the company. And these are defined as shareholders with less than half of the total shares in a company, right? And a lot of measures have been put in place by legislation to protect the rights of minority shareholders. So, for example, there is any major asset transaction must have the input of minority shareholders. Minority shareholders can apply to court for an injunction or declaration where there are derivative action, and an application could be made to the court as well for relief on grounds on unfair or prejudicial conduct. So these are some of the things that protect minority shareholders in dealing with the company. Otherwise, you find that, you know, people who, as we see in the bank that Obichukwu mentioned a minute ago, you find that people who have majority share would basically carry on as if there is nobody else that has an interest in the company.
So 306 to 309 cover in great parts. We'll pick some sections as well. The liabilities of directors. Section 296 actually provides that directors cannot issue loans to themselves from the company without consulting and informing the shareholders. And the directors cannot take loans from the companies of which they sit on the board, except the company is in the business of finance and issuing loans. Even at that, the law in BOFIA is the Banking and Other Financial Institutions Act, stipulates the maximum amount they can borrow from the company. Now, for those who have been following the scenario regarding First Bank, as information was coming out during the power tussle, it turned out that one of the aspirants for the position of directorship / chairman, board of directors, was actually alleged to have borrowed a lot of money from First Bank. Now, first, borrow money in excess of what he was allowed to borrow. Even though later he claimed that he refunded all of that money and all that, but the main thing is there was a breach of trust. He borrowed more than he was supposed to borrow. Moving on, section 303 of CAMA says directors must disclose their interest in contracts issued by the company. Because they're acting in a position of trust, if there's a contract to be executed by the company and one of the directors is actually part of it, is aware of it, is maybe brought, as we say in let's say layman's language, brought in the deal and all that, and he stands to profit from it, he must inform the shareholders. He cannot inform them after the deal. He must inform them before, and he must let them know the extent of his profit. If he does it afterwards, he's in violation, in breach. He can be removed and can be sued, because it's more like insider trading. Now, section 278 also stipulates that directors over the age of 70 must disclose their ages. There's a reason. You have to give the shareholders the opportunity to either accept you and believe that based on your age, you have experience and expertise, or reject you because they think you are not strong enough to carry on the duties of a director. You must give them that option. Section 306 subsection 5 says, even after a director resigns, such a director is not at liberty to disclose or misuse company information. He is still accountable and can be sued. This brings to mind what you call the non-disclosure agreements. Even if you're no longer a director, you must keep company secrets secret. A director must disclose if he sits on the board of another company. This now refers to public companies. If somebody is to become a director on the board of a public company, he must disclose if he sits on the board of another company, and he is not allowed to trade information between those two companies of which he sits on the board as a director. Section 307 covers that. And he must not sit on the board of more than 5 public companies at a time. If they exceed 5, at the next annual general meeting, he must drop the excess and retain his position on just 5 boards. Section 308 stipulates that each director is individually responsible for the actions of the board in which he participated, and his absence at the time of deliberations does not relieve him of such responsibility except his absence is justified. Now, directors usually hold